Welcome, everyone. My name is Bethany Servin, and I'm part of the marketing team here at UsableNet. We're so glad you could join us today. This webinar is Understanding EAA Compliance, What Businesses Need to Know. EAA, of course, is the European Accessibility Act. Your panelists today are Michele Lucchini, Vice President of Product Management here at UsableNet, and Tom Gates, Senior Associate at Reed Smith. I'm going to go ahead and hand it off to Michele to introduce himself.
Yeah, thanks, Bethany, and thanks everybody for joining. My name is Michele. Like Bethany said, I'm focusing on the product management here at UsableNet, and I started my journey at UsableNet quite a long time ago in 2001. And through my experience at UsableNet, I managed to cover multiple roles. So I've been able to deal with all the sides of accessibility, in particular helping companies dealing with accessibility. And I'm so happy to be part of this webinar. Tom, do you want to introduce yourself?
Yeah, thanks, Michele. Hi, everyone. Thanks very much for joining. My name's Tom. I'm a senior associate at Reed Smith. I'm a tech and regulatory lawyer at heart. I specialize in all things digital data, online regulation, and now digital accessibility. And I'm really here today just to give you a brief overview of what you need to do to prepare your digital services for the EAA and remind you not to panic. And this is just a little bit about my firm, Reed Smith. So we're a global law firm. We have offices all over the world, which has been really helpful for advising clients on EAA compliance because we've been able to draw on our experiences from our colleagues in the US who are very well versed in accessibility compliance and the implications for our clients when things go wrong.
So let's see the agenda for today. We'll start reviewing what the law in Europe looks like, obviously in terms of accessibility, who and what the European Accessibility Act apply to, which are the business that are impacted by the directive within the European Accessibility Act, which are the expectations in terms of actions that the business must take before June 2025, which is the deadline for the European Accessibility Act, which are the risks for not being compliant, and then we'll also cover which are our recommendation and best practices in order to achieve accessibility and be safe in regards of the European Accessibility Act. And we also thought it was useful to provide you with answers to many questions that we got in the course of the last 12, 18 months. So we'll review together the most common questions that we have received in terms of the European Accessibility Act, and then we'll also, at the end of this webinar, we'll list the key takeaways that you should get from today's session. At the end of the session, there will be time for questions. So interact with the Q&A widget of Zoom, and we'll select the questions and we'll answer them live. So with that said, Tom, do you want to start presenting what is the accessibility law in Europe?
Great, thank you. So I'm just going to start off quickly giving a reminder to those who might not be as familiar with the EAA, what it really is. It's been on a really long legislative journey, so over 5 years now, pre-COVID, if you can believe that. But what I will say is it's a piece of European Union legislation. It's a directive. And its purpose really, according to the European Commission, is to harmonize accessibility laws across EU member states, so all the member countries of the European Union. The first thing to point out here is that for those of you who aren't as familiar with how EU laws operate, this is a piece of legislation which is a directive. So it means it's essentially a guide for each country in the EU to implement it into local laws. The text of the EAA doesn't apply automatically. It needs to be what we call transposed. That's very different to a lot of other digital regulation we're seeing, or we have seen in the last few years. So the Digital Services Act, the AI Act, GDPR, they're all regulations and they apply directly to each EU member state. And what we're seeing with the EAA is that each member state has taken a very different approach to bringing it into force. Some have adopted new laws, some have amended 56 existing ones, and some have even implemented the rules in a way that actually makes them extend beyond the requirements set out in the directive. So it means that additional obligations have been introduced on top of those in the EAA text. So that means that even though the EAA is supposed to harmonize accessibility rules across the EU, the rules in one EU member state could, in theory, be much stricter than those in another country or much wider in scope. And that is what, unfortunately, we're seeing. So the starting point is a bit of confusion, particularly if you're a business which operates in multiple countries. Which rules do you comply with if they change between EU markets? And some are stricter than others, and you operate in both those markets. At this point, I will just say don't panic. And I said that at the start. You're not alone. You know, even in 2025, with deadlines for compliance coming up, we are seeing clients in one of two camps. Either they've never heard of the EAA, they don't really know what it is. Maybe someone in the business mentioned it to them and now they're panicking about it. Or they have heard about it, they're working on compliance, but they're still panicking about it. What we are here today to tell you is don't panic, and we're going to talk you through some of the ways and the practical steps that need to be taken to comply. And what we are finding is that actually clients are more progressed with accessibility compliance than they may have understood that they are. So if we just go to the next slide, I'll talk a bit about who and what the EAA applies to. I will say I'm going to talk about the regulatory requirements here. So who it applies to, the specific services, any exemptions, the deadlines, and then I'll pass to Michele to cover the actual technical requirements. So what you actually need to do and what it looks like in practice. I should say at the outset that the European Accessibility Act doesn't just cover digital accessibility. It covers physical products too. But today I'm going to focus on how the rules will affect digital experiences. So obviously the most important thing to think about when it comes to the EAA is, does it actually apply to my organization? And if it does it apply to my products and services, or some of them or all of them? Looking at the digital and online space, some of the most common sectors and services affected by the EAA are consumer e-commerce services, so buying and selling online, video streaming platforms, some electronic communication networks, so like chat services, and ebooks as well. And it applies when those services I've just mentioned are made available in the EU. So your company doesn't need to be based in the EU. For example, you could operate solely in the US or the UK, but you just need to be offering the services in the EU. So for example, e-commerce, your service is based in the UK, but you deliver to countries in the EU. And it's a very similar story for products. It applies to manufacturers and importers of in-scope products where they have been placed on the market in the EU. So you can see already how wide the scope is. It has this really broad extraterritorial remit. And businesses need to be aware of this. But I would say from an EU perspective, the notion of extraterritoriality is something we're quite used to in the European Union. So, you know, GDPR being the one that comes to mind for many. But I will say, from looking at it here, it's quite obvious. At the heart of the EAA, the baseline directive text that is, consumer services are the main focus. So if we just go to the next slide, I wanted to address some of the more common questions we're seeing. And as Michele mentioned, we have been receiving these for the past couple of years. So we put our heads together and made a list of some of the most common questions we've received, both generally in our day-to-day work and as a result of previous webinars we've worked together on. So I've just covered a few examples here of services, technologies that we get questions about as to whether they need to comply. So looking at websites and apps, first off, no, the EAA doesn't apply to every single website and app in the EU, which is quite a common misconception. It's more about the underlying service rather than the way it's delivered. So if your service is in scope and that service operates via a website or app, then yes, it would need to comply. But there's no automatic requirement for every app or website in the EU to comply. It's more about the service. Looking at archive content, and we'll talk about exemptions later on, but certain archive content is actually excluded from the scope of the EAA, provided you don't make changes to it after the enforcement date when that comes into force on the 28th of June. And then finally, a really common one we get relates to anything internal. So internet pages, employee portals, benefits portals, internal tools, all those sorts of things. Does the EAA apply to them? No, there's no automatic requirement in the directive text that means internal employee services or systems need to comply. It's all about consumer services. But of course, that doesn't mean that those services have no rules applicable to them. There's a myriad, as you can imagine, across the EU of employment and anti-discrimination laws, which might affect those services and require those services to be accessible, but certainly not under the EAA. So if we just go to the next slide, I'll just talk a little bit about how we actually comply. As I said, Michaela will talk about the practical implications, but this is more about understanding which rules are applicable to you. So if you have decided that the EAA applies to you and your services, what's the next step? Well, you need to look at the rules of a specific country. As I said, the EAA is a directive. The text of the directive does not apply directly to businesses. You need to look at the applicable law of the member state relevant to you. But which EU state might apply to you? Which member state's laws are applicable? Unfortunately, the directive itself doesn't make any provision for how to decide this. Unlike other EU legal frameworks, which do set out a method for deciding which country's regulator, for example, will be in charge of monitoring compliance. For example, NIS2, NIS2, new cybersecurity rules in the EU, the directive text there actually set out a mechanism for determining which EU member states apply, which rules apply. There's nothing like that in the EAA, unfortunately. So that really means you need to take a step back and think about general principles at an EU level, which might dictate the rules that you have to follow. And one of the most relevant principles for digital services anyway is the e-commerce directive, which is 24 plus years old. And it's the principle in there of the country of origin. The country of origin principle is subject to a number of exclusions now, but it's an assessment that you can make, which essentially requires organizations to comply with the rules of the EU member state where they are established in the context of operating those digital services. So oversimplifying it, if I, based on the definition of establishment, and that isn't said lightly, it's been developed through decades of EU case law and guidance. If I decide my organization, which is an e-commerce service established in Spain, but delivers to every country, if I'm confident that under EU laws, the rules of Spain apply to my e-commerce service, I only need to look to the Spanish transposition of the EAA as the source of the rules I need to comply with. But the problem is the concept of establishment under EU law applies EU-wide across all manner of legislation, not just accessibility. And making that establishment assessment can be really tricky. And it's something we are walking a lot of clients through at the moment, particularly those who previously may have decided that they don't have an establishment in the EU. And that might have been assessed for tax purposes, employment purposes. There's loads of other reasons assessments are made with regards to an organization's establishment. The one thing to note is that you obviously won't want to undermine any positions you've made publicly previously about your establishment. And if you are looking to make a change to that position, that you discuss it globally within your business, because it can have an implication on things like tax liability. So at the point where you've decided that perhaps you don't have an establishment in an EU market, it can get pretty tricky to decide which country's rules apply. And sometimes, unfortunately, you might need to look at the rules of every single country in the EU. But putting that to the side, once you've completed that assessment, in theory, and you know which rules apply to you, you will then have a better idea as to which set of legislation that you need to really digest and comply with. I'll talk more in a moment about the expected standards we're going to see in the digital accessibility space. But the good news is, and Michaela will echo this, largely we're expecting compliance with the EAA from a technical perspective to be measured against existing standards, which your development, web teams, engineers may already be pretty familiar with. So we'll cover that shortly, but what that does mean is that your organization may be somewhat on your way to compliance and more familiar with the requirements than you actually realize. It is also worth noting on the EAA's requirements, it's not prescriptive, it's very principles-based. It's tech agnostic, and of course that allows for those standards to be developed as time passes, and online services evolve and technology becomes more sophisticated. So it's really a constantly moving target in terms of compliance goals. Equally, there are some concrete obligations, more prescriptive obligations in the text of the EAA, the directive, plus potentially additional obligations, as I've said, at member state level in the local transposition. And that covers things like transparency and accessibility statements, or in some cases, specific accommodations which need to be made for things like audiovisual media services. So that's where you need to look to comply. If we go to the next slide, I'm just going to talk a bit about deadlines. And I do appreciate we haven't spoken about the practical steps you need to take, but that is going to be covered by Michaela after I've covered the more regulatory scope of the rules. So when do we actually need to put the requirements into practice? When do we need to comply? So looking more just at services, with in-scope services, they must all comply by the 20th of June this year, which is not far away. 115 days from now, you have to comply. The rest of these deadlines you'll see aren't as relevant to services. They're aimed more at physical products, but there are some distinctions, and you'll see mention there of a transitional period where you're offering a product and a service that are supplied together and interact. And the rules are quite nuanced depending on whether one or both of them fall within the scope of the EAA. One question we have received a couple of times over the year is, well, what does product actually mean? It's really wide, and it echoes previous EU legislation on this. It's technically a substance, preparation, or good produced through a manufacturing process other than things like food, living plants, feed, animal products. Basically, a physical manufactured item. So all in all, the 20th of June 2025 is that date that you need to be looking at. But it wouldn't be EU legislation without a few exceptions. So if you go to the next slide, there are a number sprinkled throughout the EAA of exceptions and exemptions applicable to compliance. So starting with micro enterprises, you see this a lot in EU legislation, and essentially it means that if your business would need to comply with the EAA but is considered a micro enterprise, then the accessibility requirements do not apply. The definition there of micro enterprises on the slide, so it's companies with fewer than 10 employees and a global turnover of less than 2 million euros. Moving on to the next exemption, again, this is something you do see quite a lot in EU legislation, relates to disproportionate burden. So there are some limited exceptions to the rules where compliance by an organization with the rules would result in a disproportionate burden on that organization, or it would require a fundamental alteration to the product or service. So it would completely change the nature of the product or service being offered. Looking at this exemption from speaking to regulators and our friends at UsableNet, we do think that regulators are going to interpret this exemption quite narrowly. And we think that it will only be available in really quite obvious circumstances where it would truly be disproportionate or completely change how a product would operate. So if it doesn't seem obvious or really, really blatant that this is going to disproportionately affect you as an organization, or your product or service would completely change fundamentally, it's unlikely that the disproportionate burden exemption will apply, largely because there are so many factors that are taken into account when determining if this exemption would apply. And it includes things like the cost of complying with the requirements and the ratio compared to the overall costs of providing the service and the financials of the organization and various other compliance related requirements that we tend to see across other EU legislation when assessing if something is truly disproportionate. So I would say definitely approach with caution when thinking about whether the disproportionate burden exemption would apply to you. If you are going to rely upon it, make sure you have very carefully and granularly documented your assessment when it comes to applying the exemption. And also maybe consider whether the exemption may only apply to certain in-scope products or services rather than a blanket exemption from compliance entirely. Looking at the third box, this is sort of the shining beacon in all of this, which a lot of publishers, gave a sigh of relief to. And it'll be the most relevant to this audience is this third box. So it's the exemption for archived websites and apps. So as you would expect, and as would make sense really, any footage, articles, archived content which was produced before the rules come into effect, so before that 28th of June date in a few months, as long as you don't edit any of that content on a website or app after that date, that content will not be required to comply with the rules. And that includes things like maps, mapping services, pre-recorded media, all those sorts of things, anything which would be the content of a website or an app that you are not editing after the 28th of June. If you do update something, it immediately comes into scope. Finally, the transitional period, I mentioned that briefly a couple of slides back. So the EAA provides for this transitional period where up until the 28th of June 2030, products which contain an in-scope service will have an additional 5 years to comply with the rules. So a good example of that would be in physical e-reader, they're in scope, and so are e-reader book services are also in scope. So you've got a physical product and you've got a digital service, and the EAA makes some allowances for the deadlines that and then the efforts that would need to go into re-engineering in order to continue to provide that service after the 28th of June date this year. So you get an extra 5 years, not in relation to the service, just in relation to the physical product. So we've talked about the scope. We've talked about which products or services the rules might apply to. We've talked about when you need to comply and whether there are exemptions. Let's, before we move over to Michaela to talk about the technical requirements, let's just talk about what the risk of non-compliance look like. This is one of the main questions we're getting. Who enforces these rules and who is actually checking that we're complying with them? Are individuals able to complain, or can actions only be taken by a government, for example? Well, for those of you who have an EU background or experience with EU regulatory regimes, you won't be surprised that there'll be regulators in every EU member state, every EU country. They'll be charged with monitoring compliance with the rules. Looking at, things like GDPR, we are expecting regulators to utilize AI to audit in-scope digital services with high web traffic. And that's something we actually saw in the last couple of years from data protection regulators in the EU, who were checking the top 100 websites, for example, for compliance with cookie and privacy laws. So it's definitely a tool available to them, and we do think it's something that they will use for enforcement. If a regulator were to find non-compliance, we typically expect, and in line with what we see with other regulatory regimes in the EU, a regulator would cooperate with you to remediate those issues and to address them before taking further action. We do tend to find regulators, as long as you engage with them and communicate with them, they tend to be relatively understanding. Not all the time, but some of the time. If there was a finding of non-compliance and perhaps you didn't communicate with the regulator or you didn't want to make those changes that were non-compliant, the regulator would then have various tools available to it as set out in local laws. Typically, that would take the form of a fine, but in any event, the penalty needs to be effective, proportionate, and dissuasive. And again, this language is something we see across a lot of EU legislation, including the GDPR. But the EAA doesn't specifically set out what will actually happen if you don't comply. It's left up to member states to determine this. And going back to my point earlier about diverging standards, the fact that the EAA is supposed to make everything harmonized, we're already seeing really different approaches between member states in their respective stances against non-compliance. So taking Ireland, for example, probably the most extreme example we've seen, certain non-compliance can result in fines of up to 60,000 euros, so relatively low for a regulatory fine. But in quite extreme specific examples and circumstances where there's been repeated non-compliance, this could actually result in prison sentences. Whereas in some other jurisdictions, and I'll give you a couple of examples, we're seeing things like GDPR levels of fines being introduced, so a percentage of your annual global turnover, for example, with no criminal liability. So there's already this really diverging exercise we're seeing taking place on how each member state is going to enforce the rules and take action against those that don't comply. So from doing some research online and with other clients, some countries, France, for example, have penalties for non-compliance of up to 250,000 euros, but others, Belgium, for example, from our research, fines can be limited only at maximum 50,000 euros. Sweden, we've seen examples of up to 200,000 euros. So there are massive discrepancies, and that's why it's so important to make sure that you have correctly assessed which country's rules you need to comply with, because if it is one with criminal sanctions, that's obviously going to be something you want to brief your board of directors on, for example. In terms of that criminal sanctions enforcement tool that the Irish regulator will have, we have been working closely with colleagues and other legal professionals in Ireland who are of the opinion that the sanctions, the criminal and prison sanctions will not be used by regulators, but that obviously isn't a promise that is to be found anywhere in a legal text. It's more informal commentary by the intended regulator. So definitely exercise caution when it comes to whether or not a particular regulator will exercise particular powers, because we just don't know yet how this will play out, given that the enforcement dates are not in effect yet. You may notice it's very different to US landscapes, where we tend to see class actions or private lawsuits. As you might have guessed from the last couple of minutes, in the EU landscape, accessibility compliance will be very largely and heavily regulator charged, which again is very similar to the regimes we see for data protection compliance. But before I pass over to Michele, let's just talk about the fact that you might be closer to compliance than you think if we just go to the next slide. It's not all doom and gloom, as I may have made it seem. I know it looks quite overwhelming when we look back at what we've discussed. So the scope, the extraterritorial effect, the deadlines, the repercussions, the very limited exemptions. But the final piece of the puzzle is actually what you need to do to comply. So you might be panicking thinking, oh my God, we have to comply with these rules, but you need to know what those rules are. Those with a US or otherwise global presence who've joined us today might be in for a bit of a surprise. we are very regularly seeing clients discovering that actually they're doing a lot more than they realized in the digital accessibility space, particularly due to the regulatory landscape in the US. And that means actually they're already on their way to compliance with the EAA without actually realizing it. So in the last, I would say, year, we've definitely had circumstances where clients who may be leading EAA compliance instructions, or the mandate is coming out of the EU, we're recommending to them, speak to your US counterparts, speak to your colleagues in legal in the US. And we're finding that on, majority of occasions, there is this synchronization where actually a lot of work has already been done to comply with some of the standards that we're expecting to see under the EAA. Again, Michaela is going to talk about this shortly, but we are seeing that a lot of our clients with a global presence, their dev teams, their engineers are aware of these standards and have actually already baked them into a lot of their products. Again, because of this risk of class actions, of private actions in the US. And I should say that even though in the context of comparing the EAA with the ADA, so that's the Americans with Disabilities Act, they're obviously different things, they're different legislation, and they impose different obligations. So the EAA, for example, there's regulatory requirements imposed that the ADA doesn't impose. So things like transparency statements and accessibility statements, and certain prescribed accessibility requirements for particular services like passenger transport, or ticketing machines, or financial services. But there is an overlap, and similar but not identical efforts are required on both sides to achieve compliance in terms of the technical requirements. So I'm now going to pass over to Michaela just to talk a bit more about what those technical requirements look like, and what we can see coming out of the US and how it compares with the EAA.
Yeah, thanks, Tom. Before we dive into the specific technical requirements, I would like to make a comment just as an umbrella on top of what Tom just said. So today we are focusing a lot on the legal driving force. Obviously, there are many other reasons you might want to create an accessibility program for your services and products or your digital presence. One reason on top of everything is the fact that about 20-25% of the population or the personas that are accessing your products actually might be affected by a sort of disability. Would it be a permanent disability or a temporary disability? 20% is a large number, so probably one of the most important reasons why you should really take accessibility seriously is enhancing your user base. So and the other aspect is just considering that the web population is progressively getting older and older. So people getting older might require different abilities, or may have different needs, and the expectations of the web population is not changing. So I'm not expecting that I won't be able to use the web as I'm doing right now in 40 years. So my expectation remain the same. My needs might be even more in terms of being able to use and interact with web services. So I think that these are obviously strong driving forces as well. In terms of the technical requirements, I think that probably this is the statement of this session. You might have done a lot more than what you think. Because from a technical point of view, and Bethany, sorry, can you go back to the previous slide? Yeah, thanks. From a technical point of view, the EN 301-549 standard, which is associated to the European Accessibility Act, mirrors the Web Content Accessibility Guideline in its version 2.1 AA. It is important to say that there is already a draft version of an updated version for the EN 301-549 that mirrors the Web Content Accessibility Guideline in the newest version, which is the 2.2 AA, which has already been adopted in the US and very soon will be adopted in Europe. So in case you have you're already doing something in order to protect yourself or taking conscious actions in terms of accessibility in other states, well, you are already done, because from a technical point of view, the same applies in Europe. There might be the changes and the different aspects that Tom presented before, but from a technical point of view, the requirements are the same. So in case you are already complying to the Web Content Accessibility Guideline or using it as a driver for your design development, well, you are obviously in the right path to comply. Yeah, I want to emphasize a couple of points that are on these slides, because something that is not detailed in the American with Disability Act, or we have not been seen requested often in case of legal actions in the United States, is the proof of compliance, meaning all the documentations and the proof of commitment and actions that you are taking, as it is detailed in the European Accessibility Act. So having a record of tests, of trainings that you ask your employees to take, engagement with third parties of experts that are performing audits on your sites, those are very important steps and very important documents to take in order to provide proof of commitment and proof of investment in the accessibility space. As well, having policies that are documenting the way your processes operate in consideration of the accessibility requirements is also something that would be very important. If you go to the next slide, Bethany, please. In terms of, I mean, concrete actions that you should take when you think about implementing an accessibility program, let's start with one very popular aspect, which is test automation. It is very common that we rely a lot on test automation. Well, in accessibility, this is not enough. It's useful, but not enough. So an automated test can identify only a number of issues that are part of the minority of the success criteria that are included into the Web Content Accessibility Guideline. While it is very true that an automated test is very scalable, so it's something that you run multiple times, it's something that you can ask different departments and different stages of your development life cycle to run, it cannot guarantee the full coverage of the Web Content Accessibility Guideline, thus cannot guarantee that a site scoring high from an automated accessibility testing point of view will also be an accessible website. It is very interesting that the European Accessibility Act decided to add a few paragraphs on this aspect. In few paragraphs of the European Accessibility Act, it is requested the involvement of humans in order to check, validate, and implement accessible properties. So this is to emphasize even more that automation is not a minimum viable solution. While automation is actually represents a valid help to your organization, it is because most likely also governments and agencies that will be performing tests at a first instance will use test automation to identify whether a company is actually working on accessibility or not. So having a clean automated test on your website probably is not going to provide a guarantee of protection, but will definitely be a much stronger business card in case you are checked. The other aspect is, let's not consider accessibility like a final tick on your checklist. Accessibility is not something you should do at the end of your development phase or your life cycle. It is a requirement, and the shift left concept applies very well to web accessibility. So web accessibility deals with maturity, with processes, with operations, with constant training and competencies gathering. So it is important that becomes an integrated part of the way you work. So the recommendation is to work on processes, not just on getting the issues resolved. Getting the issue resolved is important, but is not fundamental, is not crucial. What is crucial in order to create a sustainable accessibility program is making sure that you work on processes. Can you go to the next slide, please? All right, so just to address some common questions. To the first one, I already partially answered. So can automated widgets ensure European accessibility at compliance? Well, no. It is pretty clear in the text of the European Accessibility Act that the human involvement is fundamental and essential in order to implement an accessible website. Applies to testing, but also applies to who implements the website. I don't know, Tom, if you want to add any color to this one.
Yeah, I think I would just echo what you've said. I think that it really can't be understated how important it is to involve humans in the testing. I think something that we've really seen clients have issues with is relying solely on automation and having that widget in the corner of the screen, which provides the basic accessibility accommodations, but doesn't really hit the mark when it comes to complying with the general principles that the EAA is trying to achieve, those 4 objectives.
Yeah, well said. Tom, do you mind taking the other few questions? Some probably you already answered to those.
Yeah, definitely. So these are some, as I said, we tried to cover throughout the session questions that in the last couple of years we've received, but these are some additional ones. As I've mentioned, EAA compliance requirements do vary, unfortunately, across the EU, and it's really up to the member state that's transposing the rules as to how they apply. They can't impose rules that are below or lesser than the requirements set by the directive, but they can implement stricter ones or more enhanced ones, which are wider in scope or cover additional products. And in addition to the changes that we've seen from, across different markets for the penalties, we're also seeing quite specific rules from certain member states on transparency and accessibility statements, whether that's language requirements or a specific template, or even, in some markets, we're seeing obligations to set out specifically which services or elements of your service are not compliant, or the specific steps you've taken that will make them compliant in the future. So there definitely are some real diverging ways of achieving compliance in each market. But what we haven't seen, luckily, is changes between each market in what is expected technically. And we do think a lot of this is going to be based on the Web Content Accessibility Guidelines, version 2.2 AA. That's what we're expecting across the EU. We've not seen any additional technical requirements. And I think that probably makes sense because, as I said, the text of the directive, and therefore the transpositions, is intended to be quite technology neutral and agnostic and be able to move along with technology as it develops. So it wouldn't make sense to include really specific technical requirements, which could become outdated quite quickly. An analogy there is, we're seeing similar issues come up from an AI and Data Act perspective, where there might be definitions which refer to a specific type of technology, which is becoming so outdated so quickly when it comes to iterative versions of legislation being produced. So that's why I don't think we're seeing any changes to the technical requirements. The next one is which country's rules apply to my business, or a non-EU business serving the EU market. So as I said, if you don't have an establishment, first of all, double check that you don't have one, because you may have made this assessment previously. As I said, the establishment rules are not new. They have been around for a long time and they apply to every aspect of EU and member state law. And they have implications far beyond accessibility on things like taxation and employment rights and employment rules. So it may be that your organization has previously been advised or taken a position that you have an establishment in the EU or in a specific EU country. If you do, great, because that will help determine which rules apply to you. I should say the establishment rules aren't they aren't the holy grail of understanding the application of the EAA. It's largely this concept of establishment applies in relation to digital consumer goods. So there are certain things like product standards, for example, where you would need to comply with the rules in every country, but that's not a new thing. There are various different circumstances where manufacturers, for example, who distribute goods to the entire EU need to comply with specific nuances in each country. So not new there. But if you don't have an establishment and there's no indication that you've made this decision previously, then it can be the case that you need to look to the rules of every single country. And again, as we mentioned, the technical scope, the technical requirements don't appear to be diverging much, but it is those regulatory obligations, the accountability, the public-facing statements, the language you use, those sorts of things can be quite specific. And an analogy for any of our US colleagues who are on the phone right now, we're definitely seeing this in the US from a data protection perspective. We're seeing privacy laws being implemented on a patchwork basis across US states, and each of them have very different but kind of overlapping requirements. Things like reporting obligations, fairly similar. You might have to report to a particular regulator about a breach, but the way you do it, the language you use, the template you use is different between states, and that is kind of what we're seeing here. Looking at the next one, my organization has multiple websites and apps. Do I need to make them all accessible? So this again goes back to the scope. So understanding which of your services or products actually need to comply. So working backwards from there, understanding if you offer loads of different services online, looking at which ones actually fall within the scope of the EAA, not necessarily excluding those that don't, because obviously providing accessible services and products is something that we do that goes far beyond the requirements of the EAA. But from a strictly European Accessibility Act perspective, you could, in theory, then carve out understanding on the basis that you might not have to make certain services comply with specific rules. But of course, we would encourage you to, where you can, find those efficiencies and apply the accessibility accommodations across services. So no, you don't need to make them all accessible from a legal perspective. It would just be those to which the rules apply. And as I said, there are no rules that are specific to all websites and apps. It really is the type of service you offer, whether it's an e-commerce service, a banking service, passenger transit, consumer banking, loads of different things like that. It's the service rather than the means by which it's delivered. That last one I answered earlier. We've developed various internal tools. Do these need to be adapted? There's nothing specific in the EAA that says you must offer internal employee tools that comply with the rules of the EAA. But there are very likely in your jurisdiction and in various different EU member states to be anti-discrimination laws, employment laws, various other laws which may affect or bring into the scope of accessibility obligations those internal tools. So the EAA, as drafted in the directive, may not necessarily require you to make those changes, but it might be the case that you already are required to offer certain accessibility accommodations internally.
Yeah, and Tom, just adding one bit on top of this, the European Accessibility Act, and in particular the EN 301-549 standard, offer a sort of point of reference. So based on the non-discrimination or non-segregation laws, now people can actually point out a standard to refer to in order to build a stronger case. So that's also one of the, let's say, one of the reasons why the European Accessibility Act can be considered a tool for this reason. I don't know if you agree, Tom.
Yeah, completely agree and would echo what you just said. Yeah.
There are a few questions that we got on the Q&A. I would start with one, then Tom, if you want to take some. So the first one is there any obligation for an accessibility officer in the company? We have the obligation for ongoing compliance. I heard a couple of times these questions, or also something related to the need of having somebody that is certified as an accessibility expert. To be honest, I didn't find any evidence of this need. It is a best practice that we also recommend to build an accessibility center of excellence in case you're part of a large organization. Just because accessibility now is a topic that would apply worldwide. And again, it's not just a legal aspect that should be your driving force, but should be a business decision together with an ethical decision. So I don't know, Tom, if you agree, if you have any other detail, but no, I don't think that is necessary to have an accessibility officer as a role in the organization.
Yeah, that's my understanding as well from a directive perspective. As I said, it could be the case that certain member states have introduced requirements for certain organizations to appoint a responsible person, but I've not come across any. And I remember when the draft text for this directive was everyone was waiting for it to be published, there were rumors that there was going to be a GDPR style approach to this, where similar to a data protection officer would be required for certain organizations. And I think if we had seen that obligation in here, it would only apply to quite a specific subset of organizations. So nothing that I'm aware of. And I think should there be a local requirement, for example, I think it would be quite specific rather than just a general obligation on all in-scope services.
Right. Next one. How are medtech devices and their digital online website and portals are affected? So maybe I can start, and then Tom, you chime in and maybe correct what I said. Medical devices are fall into the category of products, and so there might be a little bit more to say on products. Tom already mentioned that for products, also the deadline could be different. In terms of the digital online websites or portals, I would say that if those are the portals that the customers, so the final users, access and are public, well, they should be considered services. So they should be the ones that should comply by June 28, 2025. In terms of product, probably that is what would be postponed to the 2030 deadline. Tom, what do you think?
Yeah, I mean, definitely agree that, you know, thinking about it, taking a step back, medtech device is a physical product, and looking at the scope of the EAA and the products it applies to, I would say at a basic directive level, medtech devices wouldn't be covered. So we have general purpose computer hardware systems, we have self-service terminals, consumer terminal equipment for accessing messaging services, and accessing audiovisual media services, and then e-readers. So the EAA itself, I'm not aware of having a specific effect on medtech devices, although of course there are a plethora of, especially in the EU, regulatory requirements applicable to medtech devices. So it might be the case, and you know, I think at the start of this legislative journey, there were questions as to why the scope of products and services is quite random. It contains quite a strange, nuanced list. And my understanding is that there was a feeling that many products that are circulated in the EU are already subject to very heavy regulation and did not need to be subject to further regulation when it was essentially already covered. So that would explain why there are certain more obvious products missing from that list.
So thank you very much, everyone. I'm going to go ahead and conclude today's webinar. Have a great day.